I wanted to speak to the constitutionality. I spoke first yesterday, and so some constitutional arguments came up. Recognizing I only have 5 minutes, I didn't want anyone to leave here with the misconception that this is constitutional for us to do. There were two arguments that were made during the debate yesterday. One is that Section 10 allows for redistricting to take place with the U.S. Congress. That's clearly false. Looking at the Constitution itself, Article 3, Section 10 falls within a book that includes Section 1, which is our state legislature, Section 2, which talks about the General Assembly as well, Section 3 talks about state representatives, Section 5 talks about state senators, 6 talks about state senators, 7 talks about state senators, 8 talks about state senators and representatives, 9 talks about state representatives, 11 clearly talks about state representatives, 12 is just state representatives, so is 13 and 14 and 15. And yet we would believe that Section 10, basis of apportionment, when they use the term representative, they mean U.S. Congress representative and not state representative. That's a tortured reading, especially when you consider that the immediate prior section, Section 9, talks about the apportionment of state representatives. Because, of course, at the time of the 1945 Constitution, we were apportioned to the counties. Each county got one, and then apportioned based on population. So Section 9 talks about the apportionment of representatives. Section 10 talks about the basis of that apportionment. Of course, it's only talking about state representatives. But you don't even need to read the Constitution to know that, because the governor said it in his call, in his petition. He cited that the right that we have, to the extent we have one, comes from Section 45 of the Constitution, not from Section 10. To go from 10 to 45 of Article 3, you have to go through the state lottery, riverboats, and a slew of other issues before you ever get to the one section that deals with apportioning state representative seats. In addition, the Missouri Supreme Court in Pearson v. Coster in 2012, and for you legal nerds, it's 359 Southwest 3rd 35, said that we get our right to reapportion solely by Section 45 when it comes to the U.S. Congress. And the Missouri Supreme Court in 1910 in Durham v. Missouri, 228 Mo 373, says that we can only reapportion, even despite the language saying that we could do it from time to time, we can actually only do it legislatively for our districts after a census. The other argument that was made is the argument that we call Air Bud rules here. Section 45 doesn't expressly prohibit, and therefore it allows a golden retriever to play basketball or the state legislature to redistrict without a census. It's like if my children ask me, can we have ice cream tonight? And I say, we're going for ice cream tomorrow. And they say, well, you haven't said we're not having ice cream tonight, so we're having ice cream tonight too. No, if the rule says, expressly says what we're allowed to do and something very close to it, just in common knowledge, isn't mentioned, we don't have the right to it. And that's just not common sense. That's also the Missouri Supreme Court in 2016 in Pesca versus State talked about the right to veto override bills. So in that situation, the Constitution allowed for us to come back if the governor late vetoes a bill and consider that bill in a veto session in September. And so the legislature came back in September and said, since the Constitution gives us the right to meet in September to override bills, just uses the term bills, we can use any bill that he vetoed, not just the ones he vetoed late. And the Missouri Supreme Court said, of course not. The amendment strips the legislature of the power to reconsider bills at its convenience. It can only do so with respect to the bills that were late vetoed. Similarly, this provision would be unconstitutional because it does clearly just talk about what we can do and when we can revisit the lines. And the other issue is if Section 45 only applies when we are redistricting after a census, then the rules provided in Section 45 only apply then. That includes compactness. That includes having about the same population. And so if we are, in fact, not inhibited by Section 45 with respect to things it doesn't expressly prevent, then because we are not redistricting after a census, we are free to redistrict based on the height of the population. We could have one representative for everyone over 6 feet. We could do it based on eye color. We didn't want to be even.
Gentlemen, your time has expired. Lady